I have a great pleasure in welcoming you all for today's sessions. Our today's session is a very new topic, which you are all aware very lately in December 25. This code has been actually introduced in our legislative assembly and as a bill. And now it is actually gone to the standing committee. I think it will take some more time to see this bill becomes a law. But till then, lot of intricacies on this particular topic. And today we have eminent faculties. We have Mr. Amit Gupta, who is actually a company secretary, and he is not new to our forum. He was there earlier. And as you are aware, Amit Gupta is a fellow member of our own institute, and he has been in the professional practice for almost more than about 2.5 decades in the various corporate and allied laws, providing the various services in the strategic management issues, etc., and other things. And he is also has been delivering a lot of lectures to our institute, practicing professional. He is an active participant in our various chapter programs, and he has also held various positions in Northern India Regional Council, and he has been also the managing committee in the Lucknow chapter, and he has contributed a lot of things, our research publication, etc., and other thing and all. He's a very well-known figure. And another thing is there, he is also in the Secretarial Standard Board. He has made an enormous contribution on the Auditing Standard Board. And several core group members, he was there. Actually, his contribution was actually enormous. He is also associated in a PhD, Chambers of Commerce, National Commercial Association, etc., and other things, and all those things. I welcome Amit Gupta.
Thank you, sir.
And
Thank you, Bala sir.
And we have another faculty today, Rashmi Deshpande. She is the panelist. She is also around 2.5 decades of the professional experience, and she is well versed with the legal and the regulatory compliances in the financial services sector. And she is actually a bachelor in commerce and also a qualified company secretary. And also she possesses the post graduations in the securities law. She is a very apt person to give us the insight of the security law code, which is actually coming out today. And then she also has been contributing enormously in the various sector, and she is also a renowned faculty. And she is having a very great expertise in the SEBI, RBI, PMLA, and Companies Act compliances, etc., and other things done with her vast experiences. Sudhagar, you are all aware, I need not introduce to him. Coming to the topic, I would not like to say anything on this topic because it is a very brand new topic, which is still under the discussion stage. This is in front of the expert committee, parliamentary committee it is actually. So it will take a lot of time. There are a lot of things which have been spoken about it. And then I request our great panelists to share their views, and then we start our program. Over to Amit Gupta, please.
Thank you, Bala sir, and thank you, Mehta and Mehta team, for organizing this webinar on this very apt topic, which SEBI has conceived to overhaul the securities law framework. As you know, securities law has evolved over a period of time post independence. Maybe prior to independence, we were having a securities market in India. So, if we historically go, we can see the development in a phased manner. Pre independence era, post independence era, when the Securities Contract Regulation Act came into picture, then pre Harshad Mehta era and post Harshad Mehta era. And likewise, there have been various developments from time to time, and out of this, market reactions and market prevalent practices, the SEBI has time and again came out with the appropriate deviation and changes in the concurrent law to cope with that particular nuance. What has that has made the law full of inconsistencies. Integration was missing between the Securities Contract Regulation Act and various regulations. Depositories Act, which was introduced in late 90s. So to overcome, it was long overdue. There have been series of recommendations of various committee that the securities law should undergo a complete overhaul so that it can be integrated in one single piece of legislation, and also it can provide necessary changes in the ecosystem. So thankfully, we have recently seen the Securities Market Code introduced in the Lok Sabha, and as was expected, the same has been referred to the standing committee. Now, standing committee is in the process of review, and we all have the opportunity to make the deliberations on the Securities Market Code draft bill, which still has a possibility that we can submit our views, we can make deliberations. So on that now note, I will compliment Mehta and Mehta that they had taken the initiative to start the deliberation on this particular topic. And I'm sure today's deliberation will pave way, at least to trigger the spark among the professionals to understand what all is coming from the Securities Market Code, and what all we need to understand, what all is a direction in which the changes are going to take place. There are a lot of takeaways from the Securities Market Code which are going to change the ecosystem and dynamics of the securities market, the way they are going to operate in future. One single piece of legislation will bring lot of positivities. This is not just a consolidation, but this is a overhauling of the existing legal framework also. So everything will be emanating now from Securities Market Code. SEBI has been further strengthened with its member size getting increased. It is not just member size, but it shows the vision of the regulator as to how they want to strengthen the biggest financial institution in the country and how they want to develop the securities market, as is aligned with the Prime Minister's goal to reach to and make India as a global power in the economy. I think this securities market code will be a way forward, because there are changes which are progressive, which are bringing ease of doing business also. Lot of decriminalization is proposed. So a lot of changes are there. I'm not going into those nitty-gritties. I think Kinjal will take us through, and we will be interjecting as and when the situation arises. I think I'll take a pause, and I'll request Bala sir to carry it forward.
Over to Rashmi, please. One more thing I would like to tell the participants at this particular stage, since it is in the stage of the bill, which is yet to become a law, we are also trying to understand many issues which are actually coming out, as Amit Bhai has actually pointed out. Because here what happens is this all laws, which is of 1992, 1956, 1996, these are all outlived. After the Companies Act 2030, a lot of things have undergone a change. There are multiple securities apart from what we used to talk early days, only equity and debt. There are a lot of things which has actually come out, which are all seems to be now consolidated in the regulation, this code actually, because the multiple securities has been consolidated at one stage. And second thing is, as Amit Shah puts it very clearly, this is going to be definitely a forward looking, greater protection to the investor and the EC compliances, because as our Prime Minister, our government has been talking, ease of doing the business, that also seems to be there here. I think I request Rashmi to share her thoughts on this. You are on mute, Rashmi. You are mute.
Yeah. Now I can.
Yeah.
I can.
Yes, we can.
That more than 20 years that working in a securities market, this area. and I'm very happy and I'm thankful to Mehta and Mehta firm for giving me an opportunity to speak about this Securities Market Code. And really, that Securities Market Code it will help in bringing the Indian capital markets to align with the global capital markets or whatever this international practices are there. So we will stand definitely in a better position after implementation of this code, and it will strengthen the investor confidence also. It will consolidate it, the all this apart from this SCRA, that Securities Contract Regulation Act, Depositories Act, and SEBI Act. Other acts are also there, like Companies Act. So all other acts will also, it will be under one roof, and it will be easier for the regulator also to control. But still, I feel that in its implementation and execution, there are more points to be considered. And I think it is that process is going on, and taking into consideration the investors' interest, it will help the investors a lot, because apart from the FPIs and HNIs, nowadays retail individual investors also, they are investing in the market. And with the introduction of the new types of the securities in IFSC, or in Gift City, or like that gold receipts EGRs, so many securities will come under the one umbrella, that they are trying to do the same, that under the definition of securities, there they will try to cover all these types of security. And it will definitely help in to reduce the or reduce the market abuse, and other whatever effects that we are now see during the we will discuss during this presentation. And again, I'm very much thankful to Mehta and Mehta company. I'm handing it over to Bala sir.
Over to Sudhakar, please.
Thanks, Bala, and good morning, everyone. As we all know that Indian economy is in a fast evolving phase. We already become the fourth largest economy in the world, and very soon we are going to be the third largest economy. Maybe down the line, about a decade and a half, we may become even the second largest economy also. So when the evolution of the economy is taking place, that point of time, all the even security laws and corporate laws do have to evolve. In fact, these three major laws, what Amit and Rashmi has mentioned about, like SEBI, SCARA, as well as the Depositories Act, these are all very old and archaic laws, which needs to be reviewed and rehashed completely, the way it has happened with Companies Act as well as SEBI listing regulations. So when we were having the listing agreement, if you see that, it was all the provisions were scattered throughout the listing agreement. Lot of patchwork was done and harmony was not there, even whether the interpretation or whether the implementation, lot of struggles were there. But SEBI listing regulations 2015, when it has come, it was a structured framework, and the benefits of that we all have seen for the past one decade or so. Same was the case with the Companies Act also. So whenever anything new is happening, at that point of time, whatever the gaps were there, whatever the ambiguities are there, and whatever the shortcomings are there, difficulties are there, they all can be removed. So this proposed security code, it is a consolidation of all these main three laws which are connected with the securities market, which have lived their life. In fact, SCARA is almost 1956. It's about 75 plus years old law. And other two laws are almost 30 years plus. So the harmonization between these three laws are very much required, because they're interconnected with each other. And similarly, the definitions also, okay, that whatever the definitions are there, the integration of these definitions is where, and wherever the duplication is there, that needs to be removed. So ultimately, at the end of the day, the objective of securities code is to have a structured and compliance framework, and with whatever the ease to be available to the stakeholders, that is also to be, it has been taken into account. And the investor protection mechanism, that is the main, one of the main parameters of the securities code, which also has been, the protection measures have been enhanced, and the enforcement also, the enforcement framework needs to be strengthened and needs to be as stringent as possible. So if you see the securities code, a lot of measures have been taken, whether it is a governance framework, whether it is the compliance framework, whether it is the implementation framework. Overall, I can say this is a kind of a structured framework. I'm sure that that as and when this is going to take the form of an enactment, we all will certainly get the benefits of this particular securities code. In fact, yesterday when I was in Ahmedabad, somebody asked me this question, sir, why you are taking the securities code in tomorrow's webinar? It is still in the not even I mean just in the discussion phase only. The purpose of this thing is why we have divided this particular webinar on this particular topic is that as professionals, you are to be in sync with right from the beginning. So by the time when a bill has been framed into an act, whatever the additions, deletions have been taken place, or whatever the discussions, observations may have come from different areas, then you will appreciate when it takes an enactment and the understanding will be more. Without having the background, if you simply you want to read it as and when it takes a shape of an act, you will not be able to appreciate that. So with this, I give a pause here and request Bala to take it forward. Thank you.
Thanks a lot, Sudhakar. You touched upon very, nicer point. If you actually look at it, 1956 Act, who's the director? That was the question. There is no definitions. Anybody who's having a control, whose act it used to be operate, whose board it is accustomed to operate, and all those things, finding out the director itself was a big problem. But when it came to the 2013 Act, it's very clearly set. Director means it's appointed by the board. Simple. Definition itself is very clearly set, whatever name you call it. In fact, you may be remembering, there will be a companies, they used to have the definition called a director, which is actually a misnomer. And even the Department of Department of Company Affairs, those days, they have issued a clarification also that such a misnomer designation should not be used, etc. and other things and also things. So very clearly you said that. One thing is there, I would like to put a disclaimer here. At this particular stage, we are also trying to understand, we are also trying to see what is the things, etc. and other thing and all. At this stage, with the available material which is available on public domain, we are trying to interpret, we are trying to analyze, we are giving to give our thoughts at this particular stage. So from there is no opinion, etc. can be formed, etc. and other thing and all. But as we go along, Kinjal will actually take us through. It shows a lot of good things, really speaking. As Sudhakar puts it, is the investor protection. Definitely, if the investigation, there's a time frame has been put now. 180-day time frame is there for the investigation. Similarly, when it comes to the Caesar and search also, yes, they have a power, but of course, they know to get the sanction from the special court, etc. Those provisions are actually there. Definitely, the SEBI's role, power, governance practices will get definitely strengthened to the greater extent. And again, the law is very forward-looking because the market evaluation which has taken place over the last 30, 40 years in today's global scenarios, that has been actually built in this particular code. That is what I could see at the very first reading. Because whatever the contract which has been now, whatever securities we are talking about, everything has been put one umbrella rather than olden days. We used to talk only at debt and equity. That is one thing. Kinjal will take us through this. And as usual, I request all the participants put their questions and queries on the chat box. We'll be addressing those things with the help of our expert. If there is anything left over, we'll take it at the end. Subject to time availability, you can raise your hands, you can raise your voice, you can interact with the panelists also. I'll ask Kinjal to start the presentation. Over to Kinjal.
Before that, Bala, I want to add one more point is that well, this is one of the major again that initiative taken by the government to amend these laws. The way it happened with Companies Act, the way it happened with SEBI listing regulations. Only thing is we should hope and we should represent that this act, let them take enough time, let them have enough discussions, deliberations, and all. But when they're making the law, it should be framed, thoroughly understood, thoroughly discussed and deliberated, and before that it becomes an enactment. See, the amount of struggles what we had with Companies Act, it was in a very hasty manner they have enacted that and implemented it also. Even when the rules were not ready, the act was enforced. What is the tearing hurry for that when we could wait so much of time for that? Same is the case with SEBI listing regulations. Every quarter, there is some amendment or the other bringing complexities. bringing implementation challenges and all those things. So whenever, at least from now onwards, they are framing this. We have to take lessons from the past and have to have a robust future when they're evolving these kind of new laws are concerned. Yeah, India, please take it forward. Thank you.
Let me just share my screen. I hope you can see my screen.
Yeah, very much. We can.
Right. So like we mentioned, today's topic is very new for everyone over here. So we are just going to break the presentation down into six different parts. First one being a context and background as to how we have gotten here, why this was needed. Second being the architecture of the entire new code that is being deliberated right now by the standing committee. We'll deep dive into 8 major changes under this new code. How is this looking to change the security market as we go forward? What impact this will have on the professionals, organizations, and the market at large. We will also look at various concerns that may come up and gaps and risks under this new code. And having looked at all of this, we can just look into what the roadmap looks as we go ahead under this particular code. So now we know that India's capital market legislative architecture has for over 6 decades been held together by a triad of statutes born in different era reflecting priorities and constraints of its time. So, for example, SCRA, the Security Contracts Regulation Act of 1956 was enacted to regulate stock exchanges in a pre-liberalized economy. Then the SEBI Act of 1992 gave legal personality and teeth to this regulator in the wake of the Harshad Mehta scam. And in which kind of propped up the requirement for a credible watchdog on the capital market. Then we have the Depositories Act of 1996 that addressed the chaos of paper-based settlement and gave birth to dematerialization. Together, these three statutes built a security ecosystem, but they were very fragmented. There were various inconsistencies, overlapping enforcement, etc., which was many a times exploited by market participants. Now, the Security Market Code collapses these three statutes into one and is looking to go from a rule-based compliance to a principle-based governance format and get into a unified adjudication going forward. It also looks at future readiness of the Indian capital market, given how technology is developing and how new securities are developing as we move forward in time. So, like I mentioned, SCRA was enacted when Bombay Stock Exchange was the only exchange, was a dominant marketplace, and it was looking to control speculative contracts, recognize forward trading, and just bring exchanges under government oversight. Then SEBI Act under the Harshad Mehta scam was looking to protect investors, promote the market, and regulate securities market. And then Depositories Act, it came around NSE's arrival in 1994, and subsequent trading volumes made paper-based settlement almost impracticable. And this Depositories Act created NSDL, CDSL, enabling demat accounts and electronic settlement after allowing for technological adoption in the market. Now, by the 2010, so as we see, all of these three different acts were kind of a reaction to how the market had developed over that period of time. Depositories for your paper-based trading, SEBI Act with to combat scams that were propping up, and securities contract regulation to kind of regulate stock exchanges and the capital market that was developing back then. They weren't talking to each other. There wasn't a unified ecosystem that allowed a smooth capital market in the country. So by 2010s, these three statute architecture was showing its age. There were several structural problems that were coming up. So that firstly, there was definitional inconsistency. Securities was defined under SCRA but regulated by SEBI Act. And then courts and regulators struggled with instruments when it came to units of mutual funds, government securities, derivatives, hybrid instrument, and they didn't fit neatly into this particular definition. There was overlapping jurisdiction. SEBI, RBI, central government had concurrent powers in several areas. Particularly government securities, currency derivatives, commodity derivatives, that created a regulatory turf wars and enforcement gaps. Then there was the criminalization problem. Um, Almost a lot of violations, even some even being delayed filings to a sophisticated manipulation scheme in the market could attract criminal prosecution, it can attract possible criminal execution under this existing framework. So this kind code looks to kind of make it more kind of aligned with the level of non-compliance under this particular code, and decriminalizes a lot of non-compliance under the code. But also it does have high amounts of penalties for looking at how severe the non-compliance is. Then we were looking at a limitation period. There was no limitation period before. SEBI could and initiate investigations into violations occurred 20 years ago, creating perpetual uncertainty. And then coming to the technological blind spot. The laws were silent on algorithmic trading, high frequency trading, robo advisory, and digital assets. SEBI tried to regulate these through circulars and regulations, but without much like a strong statutory backing. The legal foundations were relatively weak. There was also investor protection gap. So when it came to grievance redressal administration, which is under the scores system that exists today, um, there is no binding accessible forum for retail investors to obtain compensation for any kind of misconduct that has taken place in the market. There was also, like we mentioned, overlapping jurisdiction when it came to various regulators and central government. Now, this particular reform is not especially new. So this deliberations when it came to this particular reform has been happening for a while now. This reform conversation it began in 2011 when the government of India constituted the Financial Sector Legislative Reforms Commission under Justice B.M. Sri Krishna. Its mandate was to review and rewrite legal institutional architecture of India's financial sector to align with the needs of modern globalized economy. Now, this SLRC submitted landmark
Kinjal,
report
Kinjal,
in March.
so,
Yeah.
Kinjal, 1 minute. Can you please go back to the previous slide? Because I got disconnected. I want to say one or two things in that. So here, there's no limitation period. This is, in fact, that long desired thing because there was certain laws where it is a perpetual exposure is there to that regulator. The limitation period is always should be there. And here, what they have proposed is 8-year limitation period, which is in alignment with other laws. This is a good proposal. Similarly, if you see the weak investor protection in the scores also, I don't know how many people are getting benefited in the scores. But scores, again, the same thing there. Nobody is listening to that. Say, for example, some people are complaining the same issue again and again, again and again. And closure of the complaints is also taking a lot of time, which I'm sure that the company secretaries of listed companies are struggling with this. I think if I am not wrong, there is a proposal like ombudsman also here, the way we are having with RBI, which is going to be, I mean, very efficient and effective instead of this course platform and other things. When we talk about the overlapping jurisdictions, that also that the to the extent possible, the alignment is required among the regulatory authorities. Say, for example, if you take the Companies Act as well as SEBI listing regulations, the listed companies, the way we are suffering, okay, that the Companies Act has its own nuances and SEBI listing regulations they have its own nuances. Now, what happened is if you are a company secretary of a listed company, you have to have the challenge of to align both these acts, and then you have to complain. Comply with that. So, if the alignment is there among these things, say for example, related party transaction, that is one of the major challenge which all the compliance officers face. Right from the related party definition, the definition of related party transaction, why in case of SEBI listing regulations, it is so harsh or so wide in comparison to the Companies Act? There should be a rationale properly for that. Something somewhere wrong is happening. That doesn't mean that regulators have to make some changes, some amendments, and making it complex and making it a challenge to the compliance officers. So in the security code, this kind of overlapping jurisdictions or overlapping regulatory provisions are there. To the extent possible, they have to align together. Yeah, thank you.
Absolutely, you're right, Sudhakar. Actually, in fact, we also seen there are two issues which I have seen because I've been continuously going through the various regulatory orders, etc. People have even gone back 14, 15 years back. The issues and they are taken up and tracked up the thing where the company did not have even the documents because of the 8 years maintenance, etc. and other things. That is one thing. As you rightly say, the 8 years limitation, which is in aligned with the other regulatory laws, that is one thing very good, number one. Number two, I also come across when you say multiple jurisdictions, the same issues are taken up by both of the authorities. So that way they have to go back and tell them, no, this matter is already pending on this particular case, etc. and other things, unless that get resolved, then till this time it should be kept on or it should be something like that. All such things which has been actually happening. So probably here it is consolidating the thing, bringing everything under one roof, because now the compliances will be only under one regulation rather than many regulations. I think to the greater extent that will sort out one thing. Second thing is the time frame. Investigation which used to go on, how long, nobody knows. But here the law says it has to be completed within 180 days. That is one good thing which has actually come out here. Not only that, they have also differentiated between investigation and inquiry. Many times, it used to be get confusion at the end of the company secretaries, etc. Nothing when it comes to those things are also being addressed here. So definitely, as I said in the beginning, it is definitely very good forward looking. As we go along, we'll have to see and we'll have to wait and watch the final piece of delivery, what it comes actually. Yeah, go ahead, Kinjal.
So just
Actually, one sec.
one
Yes, Amit.
one
Yes,
small
Amit.
Acha.
one small point to what Sudhakar sir has raised a very valid point, and that is the talk of the town and key game changer that SEBI has came forward with the introduction of a limitation period, right? Because I believe there is a chapter 36 of the CRPC which, along with the law of limitation, provides certain limitation for taking cognizance of offense by the court of law, which is usually 6 months, 1 year, 3 year, and for certain offenses more than 3 years. However, in 1974, the government of India came out with the Economic Offence Inapplicability of Limitation Act, meaning thereby the enactments which are listed in the schedule to this economic offence inapplicability law, they are out from the law of limitation. That means, as far as the taking cognizance under any of these laws is concerned, they will be not bound by chapter 36 of the CRPC, section 467 to 473, but they will be governed by the law what is specifying therein. So if you see the major laws which are found in that particular law includes Companies Act 1956, though Companies Act 2013 does not specifically appear in that, but by and large courts have been taking 1956 law as replaced by the Companies Act 2013. Then Income Tax Act 1961, Wealth Tax Act, Central Excise, FEMA, Food Adulteration, Essential Commodities, IPC, Gold Control, and so on. This is one part of it. So, and now interestingly, if you see Schedule 1 of Securities Market Code, that also amends the economic inapplicability of limitation law to include Securities Market Code therein, meaning thereby, as far as taking cognizance by the court of law is concerned, my understanding goes, it is not for everything that the law of limitation of 8 year is going to be in picture. I believe they will be classifying further as to what will be falling in the limitation period under the securities code, because now securities code will be governing the limitation period as against the previous position. But we'll have to see whether it is going to be for all. That is point number one, which I wanted to bring to the table for discussion. Point number two, as you know, offenses are not in isolation. Any offense may have its roots in the company law, it may have roots in the Indian Penal Code, or it may be punishable in more than one law. What about the offense which is punishable in the SEBI enactment as well as in the IPC? So maybe under SEBI law I have a limitation, but under IPC still I can be penalized. So how far this limitation period is going to help country, I think that is also relevant. So it is a apt time when we understand it fully, and then we, if the intention is to limit the period in which the courts can take the cognizance, I think necessary representation can be made before the appropriate forum, so that we have a clarity as to whether what is intended is going to be achieved out of this or not. That's a small
So,
point which I thought.
so this is covered in the presentation and under the code is that they have provided an exception for this. So if a matter is referred by any external agency such as CBI, ED, etc., then this limitation period does not apply.
No, Kinjal, that's fairly okay. I understand that from where you are coming. I'm saying ki whatever has been provided is one part to it, right? Maybe offense for which no exception has been carved out in the Securities Market Code. No matter has been referred by CBI, ED, but it is a plain vanilla offense which is punishable in the SMC also and is punishable in IPC also. So in SMC, I have a limitation period of 8 years. But in IPC, I don't have a limitation period. Indian Penal Code says that I can punish you even in 20 years' time. Then how to deal with that? That is the point that I am bringing before the forum. Yeah, go ahead.
Right. So, like I was mentioning, the FSLRC committee submitted its landmark report in March 2013, and its principal recommendation was very radical to create a single unified financial regulator authority that merged SEBI, IRDA, PFRD, and parts of RBI functions also. Now, this recommendation was very controversial at the time and was never really implemented because everyone felt it was too radical. Regulators resisted. Political economy and of regulatory consolidation proved too complex to be able to merge all of these different regulators. But FSLRC's concern for unified principle based technology ready regulation found its way subsequently into the Union Budget of 2021-2022 speech by Finance Minister Nirmala Sitharaman, who proposed to consolidate provisions of the securities law. And that proposal has now kind of come out as the Securities Market Code 2025 today. Now, there was over 4 years of internal deliberation, then interministerial consultation and regulatory input followed before this particular bill was placed before the parliament. And now it is referred to Parliamentary Standing Committee today. Now, getting into the architecture of the new code, the Securities Market Code is divided into 18 chapters covering the entire securities market ecosystem. This is the first time Indian capital markets regulatory framework has been expressed in a single self-contained statute. Now, the primary features of this particular code is that it encompasses primary and secondary markets, market infrastructure institutions, intermediaries, depositories, enforcement, and investor protection. It is a principle-based drafting rather than prescribed specific rules, and the code lays down principles, outcomes with detailed rule making delegated to SEBI through its regulations. Now, this is a philosophical shift from the rule-based approach in the pre-existing statutes that exist today. Then there is unified definition of a single securities that eliminates the historical confusion between SCRA and SEBI Act's regulatory jurisdiction. Then you have a consolidated regulatory authority where powers which were previously exercisable concurrently by central government and SEBI have been consolidated under SEBI, reducing the dual authority problem that created confusion in the market. Now, there is a savings clause also under this particular code where it says that the existing subordinate legislation of SEBI's vast corpus of regulations, circulars, notifications continues to operate unless it is inconsistent with the code. This is kind of to prevent regulatory vacuum during the transition. So, like I mentioned, this principle-based regulation means that the statute articulates what outcomes are expected, such as investor protection, market integrity, systemic stability, and empowers the regulator to determine how those outcomes are achieved through its subordinated legislation. This kind of allows flexibility, adaptability to SEBI to update regulations without requiring parliamentary actions in a major change. And but then there is a risk also of over delegation. where if the bulk of real obligations migrate to SEBI regulations rather than being embedded in the statute, it could undermine parliamentary accountability and create regulatory uncertainty. Now, we will just look at the 8 major changes under this particular code. So, there has been a change in the board construction itself. So, from 9 members, we are moving to 15 members, allowing for specialization, dedicated subcommittees for derivatives, algorithmic trading, etc. There are 5 designated whole-time members from previously 2. At least 3 independent members are mandatory with no prior government service in the preceding 3 years, which aims at reducing the perception of SEBI as a government-controlled body. Then members are required to now disclose pecuniary interest held by themselves and their immediate relatives, where they are mandatorily required to recuse themselves from any proceeding where they have direct or indirect interest. SEBI is also now empowered to maintain a reserve fund and transfer surplus to consolidated funds of India. And the code kind of consolidates power under SEBI and tries to avoid duplication when it comes to SEBI, central government regulatory authority. Coming to the expanded definition of securities, so this is one of the major changes that have taken place under this code. So the clause 2 of the code provides unified expanded definition of securities, designed to keep it technologically neutral and future proof. So previously stocks, bonds, debentures had been explicitly defined, which have been retained. Derivatives were explicitly defined, which have been retained. But now, one of the major changes under this code is that digital and tokenized instruments have been included. So this is a very flexible definition that explicitly allows tokenized securities, digital representations of value, and instruments on distributed ledger technology, which is your blockchain technology, to be brought within the regulatory framework without requiring fresh legislation. You have investment contracts. So under these investment contracts, the code takes a functional approach. It looks at the nature and substance of the arrangement, rather its legal form. So this closes the arbitrage gap where promoters structured instruments to technically avoid SEBI's jurisdiction, where they would call it a contract while it was in the nature of a security essentially. Now, several rights in securities have also been included. So, rights arising under shareholders' agreement, joint venture agreements, and private equity arrangements, which include tag-along rights, drag-along rights, preferential rights, etc., may now fall within the expanded definition of securities. Now, this particular change has a profound implication for private equity, venture capital, and M&A transactions going forward, because this kind of expands SEBI's legislation. To what extent we still have to figure out onto private unlisted companies also. Government securities integration. So the government securities provision are partially absorbed, creating a more unified framework across sovereign and corporate paper. So again, like I mentioned, the definition of securities has been expanded significantly, allowing and now to just see to what extent SMC applies to unlisted private companies is a big question under this code. And if this kind of scope is expanded to such companies, then to what extent? So would it be for investor protection, grievance redressal, dematerialization obligations, penalty provisions? Like we still have to see to what extent this can particularly impact non-listed companies. Now, decriminalization, as we mentioned, is also one of the major changes under this code, where it's very consequential. Where today's code, where any procedural and technical lapses also can be taken in as criminal offenses. uh, this kind of is disproportionate to the liability exposure for any organization and market participants in the market. So this code kind of divides and categorizes offenses into category A and B. Category A being administrative contraventions. So these are more minor procedural and technical violations, such as delayed filings, disclosure errors, technical non-compliance with format requirements, low materiality reporting failures. And this kind of the consequences for this particular kind of offense would be more civil monetary penalties only, and not really criminalizing such offenses. But then you move to category B of offenses, which relates to market abuse. This has been explicitly criminalized under the code, and it refers to serious economic misconduct, um, where it includes insider trading, fraudulent, unfair trade practices, dealing in securities while in possession of unpublished price sensitive information, using power or influence to manipulate market prices, defrauding investors, etc. Now, this particular category can have both civil, which includes disgorgement and penalties, and criminal liability, which includes imprisonment. So, so this kind of new shift has been introduced under this particular code. Now, the maximum civil penalty under the code has been increased to up to 100 crores for certain serious violations, that which this kind of uh, penalties are rare in today's code. Now, the success of this decriminalization depends entirely on two things, according to me. How precisely administrative contraventions versus market abuse is defined, and if civil penalty amounts are sufficient and they just don't become cost of doing business. Um, so we'll have to see how this takes shape in our markets going forward.
So,
Amit
Kinjal,
and Rashmi, Amit and Rashmi, coming out of whatever she discussed so far, when we are talking, the various rights and contracts and the special rights, etc., and other thing and all, when she touched upon the private companies and rather closely held public companies, etc., and other thing and all, what will be the impact which will be arising out of this various shareholders agreement and joint venture agreement, which is given the special right to them at the time of exercising, etc., and other things and all, which is entered with that? What will happen to that?
so Bala sir, I will deal securities definition first, and then we'll answer to your particular specific question with regard to implication for a private limited company that Kinjal also raised during the deliberation. How I see the changes in the securities definition, though it is again talked in the forums and it is said that securities definition has undergone a significant revamp. I agree, it has gone a significant revamp, but if you see the construct, there is no major amendment in the securities definition. And why I am saying so? Because all that has undergone a change that is already directly, indirectly covered in the securities definition. I'll give you examples like hybrid securities. When we are talking about hybrid securities did not figured in the securities definition, correct? But can we say if I am issuing convertible debenture under ICDR or under LODR, are we not required to follow and consider it as a security? We are required. So maybe direct law on securities definition was not considering it as a security, but by applying the analogous law, maybe under the Companies Act or otherwise, we were able to derive. And historically, there has not been much of the dispute, except in few cases where the matter has gone into up to the Supreme Court level, where the apex court of the country has very categorically defined as to what does the word securities mean in the SCRA. In the Sahara matter and the other matters, the securities definition has undergone. So that is one point. I think either it was settled by apex court or it was amended by SEBI from time to time, like EGR, electronic gold receipt, is something which is not new. In 2021, SEBI came out with the amendment to include and amend the definition of securities in the SCRA to include electronic gold receipt. Now EGR is definitely, because they have the opportunity to amend the securities definition, so they have included that in the specifically in the securities definition. So point that I am trying to say, either security was covered in the securities definition, or a particular instrument was already covered, or it was impliedly covered by virtue of the jurisdiction interpretation of the court, or it was included later on. Now, what is interesting, people are saying that the third point, rather fifth point, where the tag along right, drag along right, preferential right are also now included in the definition of the securities. So people are raising a doubt whether private limited companies will also fall in the ambit of SEBI. I have my own doubts. See, the definition of securities has been amended to increase its safety net. What is safety net? Safety net means tomorrow if somebody is caught misusing the provisions of securities, SEBI should be having power enough to penalize the same. If they are misusing any of these instruments, give a different color as if the securities law is not applicable on them. But they are
Amit, there is one thing is there.
Yeah.
Since this code is going to consolidate SCRA, depository, and SEBI. Now today, SEBI has the jurisdiction over the listed companies only, whereas depository act is applicable to all companies, irrespective of whether it is listed, unlisted, public, private, etc. Similarly, SCRA is also applicable to all the companies. The only thing is SEBI, which is there, is only for the listed company. By virtue of this one single code, automatically the question of the private companies also coming into partially will actually become reality of this.
Now, absolutely right. You are right on one part, because depositories will be covering their applicability to the private limited companies also. So that is one part of looking at it. But I am saying you the other part to look at it is also that tomorrow if SEBI finds that somebody is doing a violation by creating a innovative instrument or by creating a innovative deal, so that deal can also be coming into the net of the SEBI. That is what is being endeavored. But that does not mean that if a private limited company is having a tag along right in the shareholder agreement, it will fall flat into the purview of the SEBI. It is not the intention and it will not happen. That is the clarification that I wanted to bring to the table, that that is not the intent and that is not going to happen. It is only from one perspective what Bala sir was saying, from the depository perspective being applicable to all the companies, or secondly that SEBI, if tomorrow feels that somebody has misused, as you have seen that many of the companies in late 90s and 20s have misused and created the innovative instrument, while securities definition was not wide enough to cover those instruments, and they have tried to misuse. Sahara India matter was the live case, who have played on the definition of the securities only. So need is felt that we should have a dynamic definition of a securities, so that tomorrow somebody should not get out of the reach of the SEBI while SEBI is intending to penalize somebody. I think that is the base of this amendment. Rashmi ma'am, I think she wanted to.
Yeah, yes, Rashmi.
Actually, that most of the things are covered by Amit sir. But what I just he mentioned about that SEBI should that code should cover the all types of the securities, or they should define the securities which will fall under the definition. But it is very difficult because so many types of security may come in the future, taking into consideration the global developments also, even I under IFSC also. So it may be from time to time they may come with the circular and amend the definition. That is my feeling. That now you can say something on this, Amit sir.
No, I think you are right in the way. I don't see that there is a requirement to amend it further, right? That is the only way by which regulator can expand the definition of a security. As Bala sir was indicating, being consolidated law, its applicability is going to be the vast, right? But whether SEBI law, particularly like ICDR, PIT, takeover code, will be applicable on a particular instrument or not, that will be decided on the basis of the applicability. That will not be just be decided on the basis of that now it is covered in the securities definition and private limited company will be required to follow ICDR. It is not going to happen. This is
Maybe
the,
we'll
this
maybe
is
we'll have
the,
to
yeah,
maybe
this
we'll
is,
have, yeah,
yeah,
maybe
please go
we'll have
ahead,
to,
Bala.
yeah, maybe we'll have to wait and see, because SEBI is only having a judicial authority to the listed companies. In no way SEBI can step into their shoe out of it to the private company or other places. But one thing is there, since the consolidation of the act has taken place, maybe SEBI could refer to the appropriate authority on this particular issue. That might happen actually. Anyway, we'll have to wait and see. That is what I feel.
One small point, Bala sir, to your comment that SEBI has a jurisdiction only on the listed entity. You see the Sahara India case. There were many private limited companies who have raised the money, or maybe they were converted into public limited company, but they were unlisted, who have raised the deposits from, who have raised the money from in form of the optionally fully convertible debenture, which was a convertible security, which was not falling in the definition of a securities. That's how the definition of securities got expanded. That construct of Companies Act 2013 got changed from shares to security when Companies Act 2013 was getting introduced, right? That was the basis. So point that I am trying to say, if a private limited company tries to raise the money from public, from thousands of people, which is in the color of a public issue, SEBI will have a jurisdiction, and SEBI was having a jurisdiction earlier also and now also. So there is no change as far as this particular expanse is concerned. Change is only that earlier it was scattered in bits and pieces in the different places, maybe in form of a judicial pronouncements, maybe in form of some notification circular, maybe in form of some other legislation. Now it is in one consolidated place, which is now going to provide the very clear basis to the regulator to go and prosecute those particular entities. One point which I think government can consider for including, like from electronic gold receipt, right? EGR is what? EGR is a kind of mechanism where government of India came out with the mechanisms to regulate and provide a electronic vault for gold and allow the trading. Basically, if I have a say 100 grams gold and I want to exchange it for the value and I want to take the advantage of a market, I will go and digitize this gold by creating the electronic gold receipt. And now I can trade it freely in the exchange market, right? I can take the benefit and I can convert it into the electronic receipt. Now, what is not covered currently, which I don't see that is proposed to be covered in the securities definition also, is a digital gold, which is another very prevalent instrument in the market, which is being misused by the lot of corporate houses, lot of businessmen. They are taking gold, or they are issuing gold receipt, which are issuing a digital gold, which is
Yes.
completely unregulated.
Correct.
That is not covered anywhere so far, right? If I don't know whether it is right or wrong to include that, but certainly a debate can be done how far, because tomorrow, once it becomes a scam, once it becomes a problem for the society, knee-jerk reaction comes and some regulation will come tomorrow. I can see with my experience that lot of companies have ventured into the digital gold, and there is no assurance, there is no guarantee as to what kind of framework is working for taking the money for that particular purpose or raising the fundraising being done for that. People are sentimental about the gold and they are not understanding the difference between the digital gold and EGR.
Right.
Education is one part, but more important is also to come with the right framework. Maybe I'm not saying to cover it in the definition of securities, but some other alternative mechanism should be there so that it can be prevented. The appropriate mechanism is in place.
Right.
That's my take.
The purpose of the security code is to consolidate the three enactments which are there. And all these three enactments are in the jurisdiction of SEBI. So what you are discussing is much beyond that because there are different regulators out there.
Correct.
Okay, say for example, if you are talking about the gold this thing and all, there is there. Okay, because if you are covering that into securities definition of the security code, maybe they are interfering to some extent with the RBI jurisdiction is concerned. Similarly, Ministry of Corporate Affairs jurisdiction is concerned. Already these regulators are very sensitive about as far as the intruding other jurisdiction or other regulators in their jurisdiction. So according to me, it is not like that at this point of time we are not having enactments to regulate whatever we have discussed so far. In fact, okay, by that as far as private limited companies are issuing the optionally convertible debentures or whatever it is, wherever it is entering into the, you see, that old act, Companies Act 1956, whatever SEBI has, this Sahara has done under the old act. At that point of time, these kind of measures, what are there in the Companies Act 2013 were not there. So Sahara could do that. I don't think under the present regulatory environment, Sahara can do what it did in the past. Because SEBI has some jurisdiction as far as the Companies Act is concerned, it is clearly demarcated the areas as far as SEBI is concerned and areas where MCA has to do it also. So I think let us confine our, so no doubt about it, we have done a good discussion, it is there. Okay. But at the same point of time, we also understand that there are different regulators are concerned who are very sensitive as far as their territory is concerned. any kind of intrusion by any other regulator in any enactment that may lead to unnecessary conflicts. That's what my view is.
Valid point, sir. I
Yeah,
agree. I completely
thank
agree.
you. And in fact, even several participants are writing why SEBI has to have a jurisdiction about private companies, and already they are worried about it.
Right.
Yeah,
Coming to
go
the
ahead,
fourth
Ginja.
major change under this code. Yeah. Coming to the fourth major change under this code, which is the limitation, 8-year limitation period that we already spoke about. Now, for the first time, India's securities regulator has a hard statutory limitation period for initiating investigations. Now, SEBI cannot directly inspect directly any inspection investigation after 8 years from the date of alleged contravention. So this 8 years begins from the date of contravention. Now, this aligns with document retention required under Income Tax, Companies Act, creating consistency along various regulatory domains. Now, this also provides M&A certainty where acquirers in mergers and acquisition transactions can now assess regulatory risk with greater confidence, knowing that the historic SEBI liability has been given a defined endpoint. There's also regulatory discipline which forces SEBI to be agile. SEBI cannot sit on matters indefinitely. It will have to detect, investigate, adjudicate within a defined window. Now, there is, however, an exception to this limitation period where the limitation does not apply to matters referred by investigating agencies such as CBI, ED, etc., or cases with systemic impact on the securities market. So, there is an exception provided to this 8-year period, keeping in mind that there may be cases where there is sophisticated financial frauds and Ponzi schemes, circular trading network, complex account frauds of some India's largest financial frauds have successfully concealed misconduct for extended period of time, which went on for over 8 years. And so these kind of particular frauds and scenarios aren't given statutory immunity under this particular code. Now,
Kinjal, I have noticed that you have, Kinjal, I have noticed that you have 20 more slides and you have 45 minutes time. So you have to
yeah, I'll
gallop
just
also
rush
a bit.
through. Yes, yes.
Thank
Now,
you.
coming to the fifth major change under the Securities Market Code is the introduction of market ombudsperson. Now, the code creates a statutory, um, a binding independent dispute resolution authority for investors. This is a change from the existing scores which exists score system which exists today, which is essentially like an administrative mailbox. This ombudsperson has the power to pass binding compensation awards up to a specified monetary ceiling and enforce against intermediaries and market participants under this particular code. This gives cost-free access to investors that can approach the ombudsperson without legal costs, directly addressing the access to justice problem for retail investors in the securities market, in the capital market today. This ombudsperson operates independently of SEBI's enforcement wing, preventing regulatory conflicts of interest in dispute resolution. It kind of it is inspired from the RBI's banking ombudsman scheme, which has proven effective for banking disputes, which is now being adopted to the securities market. Now, there is also an introduction of an investor charter under this particular code. So, the code introduces a statutory investor charter, which is a bill of rights for security market participants, specifying minimum standards of service, disclosure requirement, and treatment that investors are entitled to to receive from various market intermediaries. So this is a major change for how retail investors and investors in the market generally are treated under this particular code. Now, so there is an overhaul in terms of the adjudication framework. There is a single adjudication process where all quasi-judicial actions are now channeled through one unified pathway. There is an enhancement of adjudication officer powers where they are now empowered to disgorge ill-gotten gains, pass restitution orders. So disgorge ill-gotten gains, meaning if anyone has earned unfair gains or prevented, losses that they would have otherwise incurred due to some market misconduct, then they are required to return those gains along with penalties that SEBI will charge. They're also required to pass restitution orders. Restitution orders meaning if they have caused any losses to investors and the market while obtaining uh, unfair gains, then all of these gains must be returned back to the investors that have lost such money. Now, this is again a major change under this particular code. They can also issue cease and desist instructions, compel compliance, etc. Then under this code, there is a Chinese wall which has been mandated. Now, this is again a new thing that has been introduced under the code, where there is required a separation between SEBI's investigation and adjudication wings. So, the people that are collecting evidence, inquiring, etc., are not the people that are adjudicating cases with SEBI. So there is a Chinese wall that has been mandated under this particular code. Timelines have been put in place for proceedings by SEBI under this particular code. Then the penalty is also calibrated to illegal gain or loss caused, um, uh, maximum being 100 crores for serious violations, disgorgement mandatory for ill-gotten gains, etc. Because of all of this, there is an expected a surge in appeals under the SAT under this particular code. Now, I'll just run through this particular enforcement process under the code, which is it allows for firstly stage one being inspection, investigation, and search, which then leads to adjudication where designated officers issue show cause notice, and the offense is being investigated adjudicated under this particular code. Then you have companies can come for settlement under the code, and SEBI can do a voluntary settlement under this particular code. Apart from that, you have disgorgement and interim directions and penalty that SEBI issues once the offense has been crystallized under this code. And then you have the resolution where identified investors are given restitution for the losses that have been incurred by them. Under this code, there's a mandated 180-day requirement for investigations to be completed for SEBI to prevent infinite regulatory limbo. And if any extensions are required, then whole-time members must provide approval. Seizure, and like we mentioned, there's a statute of limitations for this particular process under this code. Now, the adjudication under this code is driven by proportionality, which means that the kind of level of penalties and for offenses that are being put out will have to be proportionate to if was the contravention deliberate, reckless, or negligent. if there's a past conduct and history, if there is a fit and proper criteria to render the services, then did the noticee self-report himself? Did they take remedial action? Did they cooperate in the investigation? Then were there any unlawful gains made or qualifiable investor losses that were caused? So taking into account all of these things, is the adjudication is kind of driven. Then there is a settlement system also under this code, which has been introduced through voluntary disclosure. Then the committee kind of reviews and the board then determines the settlement amount and this particular code essentially. Now, like I mentioned, disgorgement and restitution are again something that has been introduced under this code, where um, uh, there is disgorgement and restitution to the default, and the investor is identifiable and funds are sufficient to cover can the restitution essentially take place under this particular code. You have the interim orders also that the adjudication officers can pass if they think that entities acting in contravention to the code, they are going to destroy evidence, or they're going to adversely affect investors. If this interim order is valid for 180 days only, and that can be extended to further 2 years by a specialized 3-member panel if the investigation is complex and ongoing. Coming to the seventh major change under the code, which is the market infrastructure institutions, which are looked at as the first level regulators. Now, stock exchanges, NSDL, CDSL, clearing corporations have been formally designated and as market infrastructure institutions. And SEBI is empowered to delegate inspection and penalty powers to MIIs for specific operational violations. This allows real-time enforcement where exchanges can instantly freeze terminals or levy fines for margin defaults without waiting for SEBI approval, preventing systemic contagion in real life. They also have self-regulatory organization framework, which provides a clearer legal foundation for the SRO model, which enables MIIs to develop and enforce industry standards under SEBI oversight. They are also, so SEBI can also delegate powers of registration of intermediaries or investors to these particular MIIs, and they have statutory immunity when they are acting in good faith in their regulatory capacity from any kind of civil suits. Now, but these under the code, these MIIs are also required to have their internal bylaws and internal mechanisms under SEBI approval, which is their circuit breakers, market margin imposition, position limits, interoperability with other market institution, non-discriminatory access for similarly placed users, procedures for dispute resolution. Now, all of this will again be approved by SEBI and will be functioning under the SEBI umbrella and oversight. Coming to the having upgrading the current framework for the technology that is developing today. So it is one of the first Indian security statutes to explicitly acknowledge and provide statutory hooks for regulating digital markets. Algorithmic and high frequency trading, where SEBI is given express statutory authority to regulate these kind of trading environments, including AI advisory, and this kind of removes ambiguity when it came to the scope of SEBI regulation for these particular scenarios. Because of AI today, things like robo advisory has also propped up when it comes to AI driven research, and they are now recognized as investment advisory activities within this regulatory parameter. Tokenized and distributed ledger technology, we are looking at blockchain contracts that may come about later in the future. So this code essentially allows SEBI regulation under to authority to regulate such contracts also. Now, cybersecurity obligations are more granular now, and algorithmic governance and data retention for intermediaries and MIIs are mandatory under this code. Online capital raising platforms, fintech intermediaries, and digital investment vehicles have also been now brought under the scope for SEBI. And any kind of cross-border digital flows for future regulatory framework for cross-border tokenized securities have also been brought under the framework of SEBI under this particular code. Now, looking at how we are looking, how this might be impacting us going forward. Um, Document retention, penalty provisioning when it comes to contingent liabilities for any kind of particular offenses that clients have looked into currently. Then fair value of new instruments, tokenized instruments, investment contracts, and PE rights we will have to again look into how that may get valued given these new particular updates under this particular code. Audit scope has been expanded to include securities, and looking at enhanced market abuse provisioning that has been widened. We might need to get more granular with how we look at these particular things. Coming to company secretaries, insider trading framework has again been prevalently explicitly highlighted under this particular code. So any kind of board level conflict of interest disclosures we are looking at enhanced scrutiny under SEBI regulations under this particular code. Then looking at shareholders agreement and PE deal documentation review is essential to give expanded definition of securities that may bring private company governance arrangement within SEBI regulatory framework. So this is something that there is again a gray area that we will have to see how that is impacted. If there are any dematerialization obligations given the expanded definition of security, then the good news is there's reduced criminal exposure, but also there is increased exposure to monetary penalties under this particular code. Investor charter compliance, like we mentioned, is another minimum benchmark that this code is introducing for how intermediaries must treat investors and market participants in the market. We will have to see how this kind of evolves our secretarial audit also going forward. Now, for in terms of legal practitioners, we're looking at remapping of client exposure and rethinking how that might be affected given the category A, category B bifurcation of penalties and offenses under this particular code. When we're looking at M&A and due diligence, we're looking at how particular protocols, how particular rights and obligations under SPA, SHAs are going to be viewed by the regulator. When it comes to, how if this can get into private company, not get into private company, etc. You have the limitation period defense now that can be taken up. Due to all of this, there may be increased SAT litigation surge going forward. We still need to see how currently existing cases, violations will be taken up once this code is introduced, and how the transition will look like under this particular code. We're looking at increased governance standards for boards, insider trading controls, and board level disclosures to move to a significantly higher standard, and how boards must be proactive when it comes to the securities market. Cybersecurity, algorithmic governance, AI system oversight are now have statutory backing under this particular code, and they are just not considered as IT issues. They are more board level issues that must be taken up by the board, um, with fiduciary responsibilities for the company in the capital market. AO disgorgement and restitution powers mean that market misconduct now carries mandatory investor compensation obligations, and this may not, and you know, that also needs to be considered given reputational damage and fines that companies and its officers may be slapped with. Single statute, kind of uh, streamlines mapping for security markets, fundraising, being IPOs, QIPs, and makes it more predictable enforcement, given defined limitation period, reduced government risk perception around capital events. This may also be, looked at favorably by foreign funds that may be looking to invest in the Indian capital market going forward. Now, coming to impact on other participants in the market, we're looking at retail investors with over 180 million DMAT accounts in India. This code provides a significant protection to these particular investors with its investor grievance redressal mechanism that it is proposing to introduce with its statutory ombudsperson, with which who passes binding awards without much legal costs. It kind of democratizes investor grievance redressal under this particular code. Then you have the investor charter, which allows for minimum standards which are now legally enforceable rather than just aspirational, or as to how such investors must be treated and the services that must be provided to these investors. Now, there are restitution orders also from AO, which are introduced under this code, which provides direct compensation um, for any losses that the retail investors might incur due to offenses committed in the capital market. However, we know that even though these benefits have been are looking to be provided to the investors in the market, but there's still, lack of financial literacy in the market, and to what extent these are exercised by retail investors, we'll have to see. Now, coming to institutional investors, there is a single statutory reference, which means which may not necessarily always mean reduced compliance, but it allows for less confusion and more certainty for institutional investors going forward. There's decriminalization, reduces regulatory risk. Risk premium on investments, essentially. The limitation periods provide more certainty, and group level risk oversight raises compliance standards across industry going forward. Again, similarly for foreign portfolio investors, we're looking at a unifying, cleaner regulatory framework, enhanced market abuse surveillance, which increases credibility for the Indian market. Bond market integration when it comes to GSEC and corporate debt in one particular framework, again reducing ambiguity of the regulatory oversight in the market. And we're looking at kind of leveling up to how we're looking when it comes to when we benchmark ourselves to other capital markets around the world. But having looked at all these positives under this particular code, we might just want to look at where the concerns could be under this particular code. So one of the major concerns that people are highlighting is the accountability deficit. So it is said that under this code, SEBI gains broad investigative powers. They are delegated to rulemaking authority for wider range of market activities. And so SEBI is getting all of these powers, but SEBI remains accountable primarily to Ministry of Finance, not to Parliament through dedicated select committee. There's no additional oversight on SEBI. There's no kind of statutory performance audit uh, that SEBI has to probably undergo. So the concern being, while the responsibility of SEBI has been increased, is the accountability of SEBI also increased in line with that? Then there is a concern for excessive delegation risk, where real obligations migrating to SEBI regulations rather than a statute. Parliamentary accountability could be reduced. Market participants face, ever expanding um, corpus of different delegated authorities under SEBI that may be, looking to kind of execute uh, the regulations under this particular code. Long gestation and fraud risk, like I mentioned, the 8-year period when it comes to limitation of when SEBI can undertake investigations, etc. We still don't know how that will interact with other laws in the country. There may be times when there are these sophisticated frauds that may come much later than 8 years. How that would be dealt with. Then there is retroactive ambiguity in terms of existing cases and pending inquiries, how that might be dealt with if this new code comes about. What's the transition going to be like? Then coming to the Chinese wall implementation, as great of an idea that is when it comes to putting in place a Chinese wall when it comes to investigation and adjudication, but to what extent is actually SEBI able to implement this may be a concern. Also, the ombudsperson capacity risk. Now, India is a large country. We have 180 million demat accounts, which kind of translates to enormous complaint volumes. So without adequate staffing, technology, and funding, etc., the ombudsperson, will it be able to just replicate scores, or will it actually make an impact in the capital market going forward? Now, there may be, certain issues that are still kind of not dealt with, given this particular new code. So we still have multiple regulators in the finance market, being SEBI, RBI, IRDA, PFRDA, and they still many a times have coordination failures. Cross-sector products remain in regulatory gray zones, and the FSLRC single regulator vision still is far, in the future, if at all. Then cryptocurrency also is still in limbo. We don't know whether crypto assets are securities, commodities, or new class remains to be unresolved. The code provides a hook, but it does not provide a framework for digital asset regulation as such. So although this code provides the capacity to increase its scope when it comes to digital assets, but it's still not kind of clearly defined the scope when it comes to such digital assets. Then there is the financial literacy gap. Even though the rights of retail investors and protection has been increased under this code, they are only powerful if investors actually know about it and understand them. So that gap still needs to be filled, and awareness still needs to be built. Then code gives SEBI more power, but investigation rigor, evidentiary standards, and adjudication consistency our institutional culture, and whether SEBI will actually, how SEBI will cope with this particular new power is yet to be seen. There is still no whistleblower framework, so no statutory whistleblower protection or financial incentive for securities misconduct reporting is being introduced under this code. Um, India lacks the model that makes US SEC programs so effective. So in markets, developed markets such as the US, you have whistleblower programs for and financial incentives for whistleblowers who report misconducts in the market, capital market, which is still not covered under this code. There are many informal investment schemes such as chit fund, unregistered scheme, real estate, etc., with still not covered essentially under this code. So how we see this going forward is that there is going to be stakeholder submissions, public comments, clause by clause review, recommendations by Parliament, which will now take place. We will look at post committee report, parliamentary passage, and we will be looking at acts being repealed, savings clause kicking in, which preserves SEBI's existing regulations. And then going forward, SEBI updates LODR, ICDR, PIT regulations, AIF, and all of its other regulations to kind of align with this particular code. And this will be a big exercise going forward. And then we will have to see how the market evolves when it comes to tokenization framework, AI regulation, cryptocurrency, whistleblower mechanism, etc. going forward. So I think this we've covered, before in terms of how this will affect our professionals and company heads going forward. So kind of summing it up, this SEBI regulation looks to kind of, this new SMC code is looking to become more pro-business, allowing decriminalization, limitation periods, unified statute, to reduce compliance, etc. It is also looking for pro-discipline with restitution orders, 100 crore penalties, putting timelines on investigations by SEBI, etc. And we're also looking at pro-future, looking at introducing hooks for how we can be technologically ready, principle going forward for new products that may come about. We're looking at principle-based code, which is globally oriented, and making the capital market essentially ready for how things might look in the future. Thank you.
It must be, in fact, I must say that, Kijal, this is a wonderful presentation. You have dissected virtually in a very, very simple manner. In fact, I advise all the participants that whenever you attempt to read the securities code, it will be a monotony and it is very boring also in normal circumstances. So what I suggest is that you may download this recording from the YouTube channel of ours. And then whenever you are reading it, correlate it or align it with this presentation of Kinjal, then you will appreciate the act much more. Yeah.
Intel, excellently, you've done very well. In fact, very, can I put it in a simple way? A common man's understanding. You made it so easy to understand the thing, so complicated provision. When we read, actually, we get confused many things. But you have brought it very illustratively, very nicely. You could not have done better than this. Really speaking, extraordinarily, you have done. My great appreciation to you. That is number one. As I said in the beginning, it is only at the discussion stage. It will take a longer way to go and see the end of the things. So as I see from the chat box also, there are less queries are there actually, because the problem is many people are just going through it. They are trying to understand it. But one thing is very clear. It will definitely give a great professional, advancement for all the professional people. Because A, first thing, awareness is to be created. B, what are the things we'll have to understand? We'll have to get educated ourselves. We'll have to get equipped with that. and more digitalization, more and more working platform, etc. We'll have to get familiarized by the time which comes. That is what I see. It is going to be a big challenge for all of us in as well as in employment as well as working. Let us just quickly go through the questions, whatever is appearing. Was scores a part of the SCRA regulation? Scores, as I understand, is actually a complaint redressal platform which is actually resorted by the SEBI to resolve the complaints. It is a platform technology. There is nothing is a regulation or something. It is an online platform which is definitely designated to facilitate the compliance pertaining to the market regulations. What is disgorgement? I think he is referring one of your slide, I think so. Kinjan.
So the idea of disgorgement being that if any unfair gains have been earned by any person through offenses that are, that they have committed in the capital market, any kind of manipulation, any kind of unfair trade practice that they have undertaken, due to which they have earned these unfair gains, they are required to return them, and along with additional penalties that SEBI might put on them for this particular offense that they have created.
Not only that, in this particular regulation, I reading in between the line, there is going to be an expert committee who will actually assess with the reference to market regulation, what is the unusual gain or unusual losses assessment which will be done. That is how it is going to work, we don't know, but there is a mechanism has been actually provided to this extent here. Why will the SEBI monitor private companies? That is what we discussed actually here. What is the newly included? The difference of securities told by Amit. Yes, he has already given the list of items here, which I have seen it. Why will SEBI monitor private companies? Yes, we talked about it. Is mutual fund units consolidated as a securities?
Sir, it was already there. Mutual fund is already a security and it was already a part of security. And now also it continues.
Okay. Which topics, whatever it is, going forward. Okay. Impact of the professional and professional. Okay. SFC 2025 is SEBI regulated act. Am I right? How can SEBI regulate itself as a overseer? What is this question I am trying to understand? SMC 2025 is SEBI Managed Act. That is question 1. Question 2 is how can SEBI regulate itself as a overseas?
No. SMC is not created by SEBI. SMC is a parliament enacted law, which is just a bill now and will be coming a shape of a code also. So SEBI will be getting its power from parliament and SEBI will be empowered to regulate the market intermediaries, primary and secondary. It's not the other way.
What is tokenization? Somebody put out what is tokenization?
Tokenization, sir, what I understand is a framework under which you are converting your rights ownership into the real world, in the real assets, basically. Converting the rights under various provisions into the real rights, basically.
That is all the question. There are more appreciation. People are all appreciating very much. They are all saying very quite knowledgeable, quite insightful, excellent presentations. All credits to Kinjal and also panelists who answered the questions. Definitely, it is teamwork which has been put by everybody.
Bala, that one thing we must appreciate, as you know, that Kinjal is a very Bala. In fact, what I want to say is that Kinjal is a very young professional. To her age and to her experience, the way she has dissected this particular securities code is really commendable. That we must
100%,
encourage
sir.
her in future.
100%, I agree with you. 100%.
Thank
She has
you.
really done a great job. Yeah.
Yes. Bala sir, one more point just I want to bring during this discussion. I want to bring to your notice that SEBI has not issued any consultation paper for this SMC, Securities Market Code. Once the consultation paper will be issued, then I think many things will be clear, and again we can hold another session and we can discuss further about its implementation as well as execution. I know that there may be more 2 or 3 sessions. Then only it will be easier for all our this professionals, and it will be that we can implement it in a more efficient way. That what I feel. Kinjal, you have done excellent presentation. Huh? Thank
Thank
you.
you. Thank you.
Amit, your
No, I
expert
think
views.
Kinjal has covered very nicely. Appreciation to her for and as of now, the change I see generally we are used to see the changes coming from a regulator. Now, this is a change where my regulatory framework itself is undergoing a change, where your mother is going to change and your children's, which are in form of a SEBI LODR, ICDR, and all these regulations, maybe there will be some tweaking, but by and large, the framework will remain the same. But your parent organization, which was regulating, that was SEBI Act, will now be replaced by a securities market code, which will be having much more encompassing provisions, which will be much more integrated. I think that was the need of the time, and we look forward to welcome these kind of changes, which are very positive and oriented towards bringing the ease and lot of new concepts government has tried to rope in. I think they are surely going to bring lot of benefits to the society at large.
Thanks a lot. I think we answered all the questions. I will just check if anybody has risen the hands. Anybody has risen the hand, then we can see.
We expected more questions,
No,
given
because
it's
it's,
so new
yeah,
and
correct. You are
yes.
right, actually. Yeah, there is one hand. Whose hand is this? Anybody would like to interact with the panelists at this juncture? They can raise their hands. If anyone wants to interact with the panelists, please raise your hands. You can unmute and you can talk, please. Because as of now, I don't see anything. Anybody?
I think Raj Garg raised hand.
Raj Garg is there, is it? Yeah, Raj Garg, you are there? Are you there, Raj Garg? Raj Garg, you are there? That is all, I think. If there is no interactions, all the questions have been answered, we can call it a day. We can close the webinar at this stage. I would like to take the opportunity thanking to the panelists, both the panelists who have shared their thoughts. They have brought out the concepts at this particular stage. And Kinjal, once again, my great appreciation for you to bringing out nicely the concept very elucidately and within the things. It is very difficult task to go. It took at least 3 times to go through the regulation to understand. First time when I read, I got a lot of confusion. Second time, when I started reading, I thought I am understanding something, but still I have to make a note. I have to reread once again. That is what the struggle I had at this particular age. Maybe because of my old age or something, it may be the case, but the thing is, but it is true. It is very difficult. The way the regulations are framed, the way the wordings are put, it is very difficult, but you have made it all the more very easy for the participant to understand. Definitely, as Amit puts and Rashmi puts it, auto, it will definitely help to our participants. They will probably able to download this webinar. They will be able to correlate when they read it. That will be very helpful to them. Really speaking, even at this particular time, we can see almost about 150 plus participants which are there. In fact, the larger participants were 250 plus. That shows the importance of this particular topic. One thing I'm greatly, delighted to note, there are what we call the learning urge is actually growing up with our youngsters. which was not the case earlier. Now I see more and more participants, they are coming forward. The learning aptitude, knowing the things, that is getting more. There's a very, very positive signs. Definitely, I request all the professionals, let us take our profession to the next level. We keep raising our bar. We get to know the things, whatever it is. We prepare ourselves to see the future challenges. Thanks a lot. We close this webinar with this. Next week, we meet at another webinar. Thank you. Have a good weekend.
Thank you, Bala sir. Thank you, Amit sir. Thank you,
Thank
Kinshal.
you.
Have a nice
Thank you.
have a nice weekend.
Thank you.